Well, again, looking at the totality of the evidence, including the actions and responses of the police officer who responded to the scene. He was the first responder. He interviewed Mr. Jackson, determined that he was indeed a poll watcher who was authorized to do that work.
You're
he
not
talked
saying
to
a poll watcher is exempt
no,
if I could, from Section 11B.
If I could finish.
You're not saying that, are you?
No, I'm not saying that, ma'am.
Okay.
But what he did determine, based on talking to a number of witnesses, including Mr. Jackson, including Mr. Shabazz, he instructed Mr. Shabazz to leave. He talked to other people at the scene, and he made a judgment that, in his judgment, and he was the first responder at the scene, that Mr. Jackson was entitled to stay. And there was no local action taken. They concluded that the activities did not rise to the level of intimidation, and that was certainly a fact that was a fact of relevance that Ms. King and Mr. Rosenbaum.
But all that, of course, would have been taken into consideration at the time the lawsuit was filed. So the department did make the decision to file the lawsuit. You're not talking about new evidence there.
Right.
So are you saying that the attorneys that decided that the other witnesses were more credible, for instance, the witnesses who testified before the commission who said that Mr. Jackson was acting in concert with Mr. Shabazz, that he was moving to prevent members, to prevent people from entering the polls who were entitled to do that. That was all decided. What's new about well the police officer who was not charged with enforcing civil rights laws, federal civil rights laws? What's new there?
As I said, Commissioner, people of good faith and great experience can look at the same set of facts and draw different conclusions about the weight of the evidence. That, again, I talked about Pima County.
Stage at this point.
Well, again, but as you and I think agreed before, if you're in a default stage, that does not mean that you no longer have an obligation, legal and ethical, to demonstrate to the court that the weight of the evidence, you can establish the violation.
That's routine, but you had
Correct.
all sorts of evidence here. You had the affidavits. This was on video. This was not a tough one. The police officer that came didn't see what was on the video. He hadn't spoken to the same witnesses. At this point, the case was worked up. There was plenty of evidence. It was going to be slam dunk against Mr. Jackson. I just don't see what the possible reason there could be.
Again, people can look at factual circumstances and draw different conclusions, and that's precisely what happened in this case. That's apparently what happened in some of the other cases I've described. This happens all the time in the course of looking at factual circumstances, understanding 11B and the high bar that exists in that case, and that was the judgment that two career professionals at the leadership levels of the Civil Rights Division made in connection with Mr. Jackson.
But there were no factual changes. I mean, everything you're saying about Mr. Jackson was already known at the time the lawsuit was filed. What changed was simply a different administration.
Two people, Loretta King and Steve Rosenbaum, have been in the division for 30 years. They worked in the administration of George W. Bush, George H.W. Bush, and many other presidents.
Different capacities.
That is correct, but my point is simply the career professionals with 60 years of experience made the judgment. You disagree with their judgment. I respect the fact that you disagree with their judgment. They made a judgment on the merits. These are the sort of good faith, robust deliberations that occur time and time again. I've had any number of cases when I was a frontline prosecutor where I felt strongly that the facts suggested A, and my supervisors took a look at it and decided that we're going a different direction.
At the default stage?
Thank you. Commissioner Kirsnow?
Oh, thank you. Mr. Perez, to your knowledge, did Mr. Rosenbaum and Ms. King for the first time assess this case in May of 2009?
Well, I don't know precisely what I mean, they were looking at it throughout, but they also had a number of other things going on because they were supervised. Well, Loretta was the acting assistant attorney general, and Mr. Rosenbaum was overseeing the work of a number of sections. And also, I think one thing to note is when the complaint was filed, there's 30 days to file an answer, or whatever the time period is. I don't know precisely what the time frame is. So this wasn't January 21st, a case that would have been necessarily on anyone's immediate radar screen, because if it was filed the 7th or 8th or 9th of January, you still would have been waiting for those responses.
How frequently is either the Voting Rights Division section or Civil Rights Division faced with a case that is primed for default judgment?
Default judgments?
Yes.
Not very frequently.
Because it seems to me that it's a little late in the game to be reviewing and second-guessing the attorneys when it's already in a position where you're in a position where you're going to file for default judgment.
Well, I would actually respectfully disagree with that because of the reasons that we've been discussing. The department has a continuing obligation, whether or not they don't answer, whether or not they're pro se, whether or not they're represented by the biggest firm in town, to continue to conduct the analysis to determine whether there's a sufficient evidentiary base to support the charges. So I don't think it's ever late in the game or too late in the game to make those judgments. And I know in my work as a career prosecutor, we frequently, for a host of reasons, would make varying judgments at various points in cases, and that does happen.
Given, as you indicate, that voter intimidation is not unimportant, and also given that you have a continuing obligation to assess the case, the merits of the case, and you've come to the conclusion that default was not appropriate here.
Well, can I just correct that? Default?
Seeking a default judgment would not have been appropriate here. Is that correct?
Well, again, there's one. I just want to be clear. Mr. Shabazz, the person at the scene with the stick, we sought the judgment and obtained the judgment because we made the conclusion
you obtained a certain injunctive relief.
Correct.
And
Right.
We don't have time to
I've
get into that.
heard it referenced, including in the chair's opening statements, that we dismissed the case, and I just want to make sure the record is clear about what occurred in the case.
If there was a concern about pursuing default against anyone else, or a broader injunctive relief against one of the defendants, was there any consideration given to simply making a proffer, simply pursuing the case as opposed to going for default?
Well, they had not showed up.
I understood that they had not showed up, but you're in a position where you could obtain judgment. And if you had a concern about default, why not simply move forward with the case instead of simply going with default? It seems to me that there's two avenues you could have pursued here.
Well, the avenue that was chosen by both, the avenue that was chosen in this case is, I think, a very reasonable avenue, which was the avenue of choosing the default judgment against Mr. Shabazz. But
in Pima and Mississippi, did Ms. King and Mr. Rosenbaum, if you know, make the decision to decline pursuing those cases?
Those cases were in the prior administration, and the person that you'd have to ask about why those cases were not pursued would be the prior Assistant Attorneys General for Civil Rights.
Okay, you don't know who made that decision?
Not off the top of... I know the decisions not to proceed were decisions that were, as I understand it, made by the political leadership in the prior Civil Rights Division.
Okay.
I don't know who was in charge when, and because there was a fair amount of movement.
Was there any political leadership involved in the decision not to pursue this particular case any further than it was?
No, the decisions were made by Loretta King in consultation with Steve Rosenbaum, who was the acting Deputy Assistant Attorney General.
In Pima and Jackson, as I understand it, the facts, at least as adduced by some investigation, were that someone had firearms, were intimidating, apparently, in my estimation, at least in a colloquial sense, potential voters.
Mr. Kirshner,
Thank you, Mr. Chair. I'll yield.